Unlawful detainers. The California eviction lawsuit. Unlawful detainers, or UDs, are California's fancy name for an eviction. This is the overview of the actual process. We're going to go through this process as if you are explaining to a client what's going to happen if they're somewhere in this process already. So we're assuming they're coming to you at the notice phase, the phase where they've received a summons and complaint, or after that phase, in which they need to file a response, or they have failed to file a response and a default has been entered against them. The most important part of this process to point out to someone who is in the middle of the process somewhere is that the only time that somebody can be locked out of their house or put out is when a court tells a sheriff to do so. And that's at the end of both sides of this chart, where you see the box that says notice to vacate, followed by a lockout. The notice to vacate is issued by the sheriff, and the lockout is performed by the sheriff on or after the date that the notice to vacate states. However, these cannot be issued by the sheriff unless the court deems that a default has been entered properly, or the client has gone to trial and lost, and the court has determined that the notice should issue. So let's start at the beginning of the process. The first part of an unlawful detainer is the notice. A notice to terminate tenancy, a notice to pay rent or quit, a notice to cure or quit, and there are many other types of notices which can be used to support the unlawful detainer. The notices are very important because they are actually the backbone of the unlawful detainer. And when you're looking at a notice, there are options to either cure the notice, if it's something, for example, like to pay rent or quit within that amount of time, or it tells you specifically what type of violation has happened to require that the person must vacate. Important things to explain include the fact that after the notice expires, the only thing that can happen is the filing of the unlawful detainer lawsuit itself. So, for example, if you receive a 3-day notice to pay rent or quit, after those 3 days, if the tenant does not pay rent or quit the premises, they cannot be forcibly put out. They must then be served with a lawsuit and go through the entire unlawful detainer process if the landlord wants to actually evict them. There are several different types of notices. They can be grouped into a couple of different categories. The notice to pay or to do something or to leave. The notice to leave for illegal activity or nuisance, which does not include an opportunity to cure or fix the problem. A notice to leave for no reason at all. In California, there are situations where the landlord can ask the tenant to leave for any reason. They are going to move back in or really giving no cause at all. These are called no-cause notices, and they need to be given in much higher days. So, for example, where a notice to pay rent or quit might be given with a 3-day notice, a notice to terminate tenancy for no cause would have to be 30 days if the tenant has been with the landlord for less than 1 year, and 60 days if the tenant has been there for over a year. Additionally, there are special rules which apply if the tenant participates in subsidized housing, or is a tenant after foreclosure, or lives in a mobile home. These situations will increase the number of days which have to be stated on the notice in order to give the particular tenant time to act within the subsidized housing framework in order to move out or in order to fix the problem. The next thing which a tenant may receive is called a masking letter. A masking letter is a letter which is generated by the court which states in kind of very long-worded New Courier font that the tenant has 60 days under which the action by the landlord is going to be masked. That means that if anybody actually looks it up, they won't be able to tell that a lawsuit is going on at that time. The important thing to relay to the tenant is that this is not letting them know that they have 60 days to wait until they can do anything about the unlawful detainer lawsuit. All it's telling them is that an action has been filed. There's no action which is required on their part, but they should know that a summons and complaint is probably on its way, and that if they receive one, even though the case will be masked for 60 days, they must act upon it immediately. Another thing which the tenant can decide to do at this point is to act proactively and go down to the courthouse and get a copy of the summons and complaint on their own. They are not required to do this. In fact, the plaintiff is required to actually serve the notice on the defendant. However, if the tenant is worried that they may not be served properly and that a default may be entered against them, the tenant may decide to go down and pick up a copy of the summons and complaint on their own. The next step is the summons and complaint itself. This is the cover page for the California Unlawful Detainer, and the most important part of it is the first line within the box the big box with all of the text that you see here. It says you have 5 calendar days after this summons and legal papers are served on you to file a written response at this court and have a copy served on the plaintiff. To calculate the 5 days, count Saturday and Sunday, but do not count other court holidays. If the last day falls on a Saturday, Sunday, or court holiday, then you have the next court date to file a written response. This is very important because when the tenant receives the summons and complaint, they only have these 5 days to file a response with the court, be it an answer, or a demur, or a motion to quash. Now, if they don't file anything, then on day number 6, the plaintiff can come in and petition the court for a default judgment, which will mean that the tenant loses automatically. And then that letter from the sheriff is going to come that's going to say that the tenant has to move out. It's a very short time period, and so it's very important that tenants pay attention to this box. It is written in both English and Spanish. However, most of the time tenants don't read this portion because of the small font and because they don't know what they've received, and so they oftentimes ignore it and put it aside, and this can cause very many problems for them if they don't pay attention. If you have a tenant who brings you a summons and complaint and asks you for your assistance with it, the first thing you want to do is review the notice itself. Like I said, the notice is the backbone of the unlawful detainer complaint, and so you want to check to make sure that that notice is accurate. If there are any problems in the notice, then that might destroy the unlawful detainer at the trial stage. You want to ask the person if they've tried to cure any of the alleged lease violations. So, for example, if the notice says that you are being evicted because you have a dog that you have not gotten rid of, then the question will be, was there ever a dog? Is the dog still there? And did you get rid of the dog within the 3-day period? If the tenant actually fixes the problem within the time stated, that is called curing the notice. And if you cure the notice, then that can be an affirmative defense to the unlawful detainer. Step number 2 is to look through the complaint itself. Make sure the complaint matches the notice. So, for example, if the complaint itself states that the tenant owes $825 in back rent, but the notice states otherwise, then that can be something which can be demurred to. You want to review the veracity of the allegations in the complaint with the client, and you want to look through each and every paragraph of the complaint to find any technical defects. Because the unlawful detainer is a summary proceeding, which means everything happens in one proceeding, there's no separate proceedings for different types of things, and the court trial comes very quickly, it's very important that each part of the complaint be absolutely flawless and that the notice not be defective. If there are defects in either the complaint or the notice, the unlawful detainer will not stand, and the court will likely throw it out for lack of jurisdiction. Step 3 is the tenant is going to want to file a response to the complaint. So like I said, they can file a demurrer, or as pictured here, they can file an answer, which is the most common response to the unlawful detainer. And what they do is they go through each of the steps and check off the important pieces of it. The most common error which I see in the unlawful detainer answer is in box number 2, or paragraph number 2. Paragraph number 1 says defendant, and the person just writes their name in there, so that's pretty easy. Number 2, the defendant is to check only one of the 2 boxes. The first box, A, says defendant generally denies each statement of the complaint. Do not check the box if the complaint demands more than $1,000. So this is where you have to go into the complaint and the notice and see what it's about. If the tenant is facing a notice which says that they failed to do something, but has nothing to do with money, then 2A can be almost always checked. However, if the tenant is facing a notice which says that they failed to pay rent, then the amount comes into play. If the complaint demands more than $1,000, then the tenant usually should not check this box. However, if the tenant faces a complaint which says that they owe less than $1,000, then they may check this box. If not, if the defendant is facing a notice which says that they owe $1,500, then they're going to have to move to box 2B, which says defendant admits that all of the statements of the complaint are true except. And here's where the big problem comes in. Folks check 2B, but they don't mark the except paragraphs. They don't say within the box underneath, under 1, what are the statements that they disagree with. And so if the complaint says that the defendant owes $1,500 and the defendant checks 2B, then they will admit to owing $1,500 unless they've stated specifically that they disagree with that amount. They can state that down underneath 2B1, or they can just put the paragraph numbers that they disagree with. But it's important that they either state that the following are true except and put the exceptions in there, or put that they have no information under 2B2. If they don't do this, they run the risk of going to trial with a statement that says that they admit to every statement of the complaint and losing automatically and not having a chance to present their evidence. In paragraph 3, the affirmative defenses which are recognized by California are listed out, and the defendant can go through and check which ones apply. For example, is there a habitability problem? Or has the tenant repaired and deducted, and they're being given the notice in violation of the laws of repair and deduct? Or, for example, is the plaintiff only filing this lawsuit to discriminate against the defendant or retaliate against the defendant? Or has the plaintiff changed or canceled the notice to quit? For example, by accepting rent after the notice was issued, or issuing another notice off of the notice which was attached. All of the named defendants must answer. If they fail to do so, a default judgment may be entered against them. If one person answers and another person does not, then person number 2 can get a default judgment entered against them, while person number 1 may proceed to trial. Both of the defendants, if there are 2, can answer on the same form. However, it's important to note that even though multiple defendants can answer on the same form, they must file separate fee waivers with the court if they don't wish to pay the filing fees. Unnamed defendants can file a prejudgment claim of right to possession if they have defenses which are not stated that the named defendants have. What this means is that someone whose name is not on the summons and complaint can request to join the lawsuit. Why would they want to do this? There are obvious worries in that if you add yourself to a lawsuit, you may be facing an eviction on your record and the same lockout as someone whose name is on the lawsuit. However, when a sheriff comes to lock up a residence, they will not ask who are the people who are named on the complaint. They'll simply lock out all of the people who are there. So if someone is living there who may have a defense, they might want to file a claim of right to possession in order to make sure that their rights are considered by the judge. Recently, as of January 2013, the claim of right to possession does not have to only be filed pre-judgment. It can actually be filed post-judgment as well, and it can be filed all the way up to the point where the sheriff comes out for the notice to vacate. And so, if you have a defendant who is currently a tenant or someone living in the property who is not named on the summons and complaint, they should look at whether or not they want to join the lawsuit, and they can do it at any one of those times. Of course, doing it earlier rather than later would protect their rights more, just in case anything happens with the sheriff. But they want to make sure that they understand that they have an option to do so. When the tenant is drafting the answer, they want to list their affirmative defenses, which are those check boxes in paragraph number 3. They also want to attach any documentation or any notes as to what actually went wrong with these particular things. Checking the box for discrimination but not stating anything about it may be difficult for the client to bring up later on in court. They want to make sure that they give the judge something to look at ahead of time. Additionally, if they're claiming that habitability is a problem, the second page of the answer in the prayer requests that the changes and fixings be done to the property as part of resolution of the matter, and so the tenant is going to want to check that as well. Most often, the person who is filing the answer or the responsive pleading is also going to want to file a fee waiver. The fee waiver is going to allow them to file the documents without paying a specific fee to the court. Currently, the fee for filing an answer is about $240, and so it's quite, most people want to file a fee waiver in order to avoid that fee. Of course, the fee waiver is going to be granted upon low income status, and so there's a questionnaire in the fee waiver as to the type of income that you receive and how much, and the court will make a determination based on the income provided whether or not to waive the fees. Lastly, the person filing the response is going to have to begin to fill out a proof of service. What the proof of service is a document telling the court that the document of the answer or the responsive pleading was filed and that served on the opposing counsel. Once the answer has been filed and served on the plaintiff, and so the plaintiff then has a responsibility to set the case for trial and then sign the original. What that means is that the plaintiff will be returned to the court after the court service has actually happened. Issue a trial date. And this could be as simple as generally the tenants don't have to do anything when they receive this. However, there are some important things to look out for. For example, on paragraph 3 of this form, it says jury or non-jury trial, and the plaintiff will either request a jury or non-jury trial. Most often, the plaintiff will request a non-jury trial. And so, if the defendant wants a jury trial, this is a good instance for them to be able to request that. They can take the same form, and instead of checking the box that says request to set case for trial on behalf of the plaintiff, they will check the box that says counter request to set the case for trial by defendant. And then they have the right to request a jury trial. They can also say a different estimated length of trial, which is under 4A, or they can say under paragraph 5 that they're not available on certain dates. The court will not necessarily always stick to whatever dates the plaintiff or defendant required, but will consider these dates in scheduling to make sure that both parties are able to attend. After these are filed, then the notice of trial will come out. And it looks a lot like this. And what it's going to say is there is a trial coming up, and it's on this particular date, at this particular time, in this particular department. That's the courtroom that it will be heard in. And then it'll tell you who this was sent to. So, for example, it'll have the name of an attorney, if the attorney is representing somebody, as is stated here, or it'll have the name of a self-represented litigant, which is the blacked out portion underneath. And this will let both parties know who is represented and who is not, and who received this actual notice of trial date. It's very, very important that the tenant and the landlord appear at the trial. If one does not appear at the trial, they risk losing automatically. If the person would like to be represented and they are not represented at this time, they can contact the private bar or legal aid association to see if they can actually have someone represent them at the trial. Of course, it's important for them to do this as soon as possible. If they can do this at the answer stage or right when they receive the notice and the summons and complaint, then that would be yet better. But it's important to do it before the trial so that your attorney has time to prepare the case. Additionally, something which can be done at this stage is if the trial date is something which absolutely cannot be met by either of the parties, they have an opportunity to file a motion to request a continuance. They can file an ex parte request to the court, and the court will consider whether or not to hear the case at a different date. After that comes the trial. And there's no real document for the trial, but the trial really is going to go one way or another. Either the plaintiff is going to win or the defendant is going to win. If the plaintiff wins the case, then the notice to vacate will issue. They can put in for a writ of execution, and the defendant will receive a notice very much like this on their door, saying specifically the date and time that the sheriff is going to come out. It is not necessarily going to be that time, 6:01 a.m., as it's stated here on this notice, but that's the earliest time that the sheriff can come out, and the tenant must be ready to be evicted at that point. If they are not, their things may be locked up and they may be charged storage fees until they can get the landlord to agree to a time that they can come to pick up their belongings. But they will absolutely no longer be able to live there, and all people and animals, I suppose, will be locked out at that specific point. If the tenant goes to trial and wins, then the tenant will be able to stay. If it was a situation where they had not paid rent, or the notice stated they had not paid rent, or they had not been paying rent during the time of the unlawful detainer, they will have to pay back that money to the plaintiff and then be able to stay. If the tenant receives a notice to vacate, then one thing that you can do is assist them with something called a stay of execution. What the stay of execution is an ex parte motion asking the court to give them a little bit more time to move. This is dependent on two different things. Number one is how much money they can pay to the court to stay, and number two is the hardship which they would incur if they had to move out on the given date. They cannot file this until they receive the notice to vacate, because you actually need the number that's printed on the notice to vacate in order to file a stay of execution. So the first thing you want to ask them is how much money they'd be able to pay to the court in order to file the stay of execution. The amount of money that they're going to have to pay is based on their rental amount. They can ask for as many days as they want, from one to really an indefinite day. There's nothing in the statute. However, the court will decide whether or not the hardship to the plaintiff and the defendant merits that amount of time asked for. And so asking for, say, 120 days is usually not something which the judge may be inclined to grant. We've seen usually 30 days being the max that is safe to ask for at a given time, even though there's no statutory maximum. Another important thing to consider is that all of the days which are requested must be paid upfront in a non-refundable bond. So, for example, the tenant's rent is $1,000 per month, and the tenant wants to request 30 days to stay. The tenant will have to pay $1,000 upfront to the court before this time begins, and even if they move out ahead of time, they're not going to be able to get that money back. And so somebody asking for, say, 120 days is going to have to pay that multiple of that amount of rent. And so you would take the 30 days of the month, you would take the $1,000 divided by the 30 days, and that would give you the amount per day that the tenant is going to have to pay to stay. And so you would multiply that by the number of days that they're wanting to stay. 1, 2, 5, 10, 15, 30, 120, for example. And so if the tenant could only, say, pay $500, then you can let them know that asking for a stay for longer than, say, 15 days was likely not going to work for them. Because even if the stay is granted, the court will require that money up front, and if the money is not paid, then the stay will be denied, and the person will not be able to stay beyond the time of the notice to vacate. Then the tenant has to show hardship. This has nothing to do at all with the merits of the case, or whether or not the tenant was likely to lose or win at court, or whether or not they had a fair hearing. It has everything to do with how difficult it would be for them and their family to move out on the date stated at the notice to vacate. And so they want to stress medical problems. They want to stress issues with children that can't be moved. Anything which is a hardship or difficulty to them at the time, which is the reason why they can't move out on time, should be stated there for the court's consideration. Another thing that can be done at the notice to vacate stage is a motion to set aside the judgment. The motion to set aside the judgment is most commonly used in two situations. One is when the tenant missed their opportunity to file a response and they got a default judgment issued against them. And the second is if they missed the trial for a very good reason and they had a judgment issued against them. Two reasons that they want to be able to state. The first would be excusable neglect. So in other words, the client did not file an answer, or they didn't go to trial, but they had a really good reason and they had good underlying defenses. A good reason, for example, would be that they were in the hospital at the time that the summons and complaint was served, and they were not able to answer it because they immediately went into the hospital and they weren't able to actually get the help that they needed and get the forms they needed in order to turn in an answer. Secondly would be a motion to set aside for non-service. This means the person was not actually served with the unlawful detainer, but they have to be able to show this. So for example, if they have plane tickets showing that they were out of the country at the time that the proof of service of summons says that the tenant was actually served, then they may be able to receive a motion granted on these grounds. This is not very common. It's very difficult to prove up that you were not served, especially if the plaintiff has filed a document in which the process server or the person who served the document states specifically that they personally served that individual. Because of these things, it's very important also to explain to the tenant during the process that they have options other than just going to trial. If they move out before trial, then they're able to file something called a notice of surrender of possession. If they do this and serve it on the plaintiff, then there could be no eviction put on them, and the case would automatically convert to a civil matter. And so if which with its regular required noticing and its much longer trial time. And so if, for example, the plaintiff wanted to go against the defendant for a lot of back rent, then that case would have to be tried separately and would go much more slowly. And even if the tenant lost in that situation, there could be no eviction put on their records. Additionally, another option that the plaintiff and defendant have is to settle the case. This can be done from the moment that anything is filed all the way up to right before the trial. In fact, if the plaintiff and defendant walk in for trial and they're unrepresented, the judge will most likely suggest that they engage in mediation to see if they can solve the problem and settle the case without having to go to trial. This is a good option because oftentimes the parties can come to some sort of resolution which is more favorable to both of them than something that the judge would be able to award them at court.